Hey everyone, we're going to jump right into a topic today that is so important for anyone who's caring for an aging parent or loved one, or thinks they might be someday. We are going to build your legal toolkit. We're talking about the 5 key documents you absolutely need to have ready before a crisis ever hits. All right, let's get into it. Look, the whole point of this is to get out of crisis mode. We want to stop reacting to emergencies and start planning ahead. Because honestly, when it comes to your loved one's health and their finances, being prepared isn't just a nice idea, it is everything. I want you to pause and really think about this for a second. The question isn't, would the doctors be nice and listen to me? It's, do I have the legal paperwork that forces them to listen to me? Because trust me, in a hospital, those are 2 completely different things. And that's really the hard truth of it. Your good intentions, the fact that you're the oldest child or the one who lives closest, well, none of that grants you legal authority. Hospitals and banks run on paperwork, and if you don't have it, your hands are completely tied right when you're needed the most. This right here, this is the main idea. This is what we're aiming for. When you get this stuff done ahead of time, you make sure that your family stays in the driver's seat. It means the decisions are made by the people who know and love your parent, not by a judge who's never met them. So let's start building that toolkit. The first place we have to focus, and usually the most urgent, is healthcare. Let's talk about the 2 documents that are your absolute essentials for navigating any kind of medical situation. Okay, first up is the durable power of attorney for healthcare. Sounds complicated, but it's not. Power of attorney just means giving someone the power to act for you. In this case, it's for healthcare. Your loved one picks a person they trust, their agent, to be their voice if they can't speak for themselves. And really important, this power only kicks in if a doctor says they're unable to make their own decisions. And what can this person do? Well, pretty much everything. They can talk to doctors, choose treatments, get access to medical records, and they can make sure that any really tough decisions are made based on what your loved one would have wanted. It gives you the power to be their best and strongest advocate. Now, working right alongside that power of attorney is something called a living will. This one's a little different. It's not about choosing a person, it's about stating specific wishes. You can think of it like a letter written directly from your loved ones straight to their doctors about end-of-life care. This document tackles the really tough questions. Do they want CPR? Do they want to be on a ventilator or a feeding tube? By writing these wishes down, your loved one gives you an incredible gift. They remove the awful burden of you having to guess what they would want in the middle of a heartbreaking situation. So you see how they work together, right? It's like a 1-2 punch. The healthcare power of attorney gives you, the agent, a flexible voice for all the unexpected things that can come up. And the living will is your loved one's direct voice, giving clear instructions for specific situations. You really want both. Okay, once you've got the healthcare side buttoned up, it's time to look at the other major piece of the puzzle, the money. Because a health crisis can turn into a financial crisis in a heartbeat if nobody has the legal authority to pay the bills and manage their affairs. So, just like the healthcare version, there's a power of attorney for finances. It's the same idea. Your loved one appoints a trusted agent, but this time it's to handle all their financial stuff. This is the document that lets you step in and pay the mortgage, talk to the bank, or handle their investments if they can't do it themselves. We're talking about the practical nuts and bolts of daily life here. Having this document means you can keep things running smoothly. The light bill gets paid, the taxes get filed. It prevents a total logistical nightmare from piling on top of an already stressful health situation. All right, next up is the living trust. This one's a powerhouse for managing assets. The easiest way to think about it is like a box. Your loved one puts their big assets, like their house or savings account, into this box. They control the box as the trustee, but they also name a successor trustee who can seamlessly step in and take control of the box if they become incapacitated. The best part, no court has to get involved. And finally, we have the one everyone's heard of, a will. A will is actually pretty simple. It's just a set of instructions for what to do with a person's stuff after they pass away. That's it. It says who gets what and who's in charge of making it happen. Now, this is so important to understand. The biggest difference is timing and court involvement. A living trust works while your loved one is still alive, helping with incapacity and after they pass away. And crucially, it avoids that public, expensive, and often very slow court process called probate. A will, on the other hand, does nothing until after death, and it must go through the probate court system. So we've seen all the tools you need for a good plan. But now I have to show you the flip side. What happens when none of this is in place? Because this is the exact situation we are trying to help you avoid. A lot of people think that if something happens, the spouse or the kids just automatically take over. That is not true. Without these documents, you have to go to a court, hat in hand, and ask a judge to give you the authority to make decisions. All of a sudden, control is out of your hands and in the hands of the legal system. And that process, it's often called a conservatorship or guardianship, and it's a nightmare. It's public record, it can cost thousands of dollars in legal fees, and it is slow. Just imagine having to get a judge's permission just to pay your mom's electric bill or approve a simple medical test. That is the reality you can completely avoid by planning ahead.
Okay, I know that last part was heavy, but you know what? Now you have the information and that is powerful. So let's finish up by turning all this knowledge into a simple, clear plan you can actually use to get some peace of mind.
First things first, you are not alone in this. The absolute best case scenario is to hire an attorney who specializes in elder law. They're the experts. But there are other people who can help too. Social workers, financial advisors, even just doing your own research can get the ball rolling. Build yourself a little team.
So here it is, your action plan. It's just 3 steps, and it all starts with step 1, having the conversation. I know it's not easy, but it is truly one of the most loving and important conversations you will ever have. After that, you find a pro and you start pulling together the info they'll need. See? You can do this. So I'll leave you with this question. What is the one conversation, the one small step you can take this week? Because getting this stuff handled isn't just about legal documents. It's a genuine gift. It's a gift of clarity for your loved one and a gift of peace for you. Thanks so much for joining me.